Good evening, everybody. Suzanne Dibble here, data protection law expert, coming to you raw and uncut from a hotel room in Birmingham. Very nice hotel room it is too, and I nearly forgot to do my video for today, being in a different environment. I just put my pyjamas on, was about to get tucked up into bed and thought, oh gosh, I know there's something I've forgotten to do. It's my video, so here I am. And I was just finalising the GDPR checklist earlier today. If you've bought the pack, that should now have winged its way over to your email. And in the course of just finalising that checklist, I came across a topic that I haven't actually covered yet, which is DPIAs. Now, you might not have heard of those yet, so I'm going to tell you all about DPIAs and whether you need to carry them out or not. So, what is a DPIA? Well, it stands for Data Protection Impact Assessment. And it's a process designed to describe the processing, assess its necessity and proportionality, and help manage the risks to the rights and freedoms of natural persons resulting from the processing of personal data by assessing them and determining the measures to address them. So in shorthand, it's assessing the risks of the types of processing that you're doing. And the Working Party guidance states that DPIAs are a process for building and demonstrating compliance. So when is a DPIA required? And I'm going to read this out from Article 35(1) of GDPR, and then I'll summarise it for you. But where a type of processing, in particular using new technologies, and taking into account the nature, scope, context and purposes of the processing, is likely to result in a high risk to the rights and freedoms of natural persons, the controller shall, prior to the processing, carry out an assessment of the impact of the envisaged processing operations on the protection of personal data. So I'll just pick out the key bits there for you. So it is when a processing is likely to result in a high risk to the rights and freedoms of natural persons. So I suspect for the vast majority of you, you will never have to carry out a DPIA, okay? But because there might be some of you that do need to, I want to at least raise it as a flag in your consciousness so that it's at the back of your mind. Okay, so if there's any chance of a processing being likely to result in a high risk to the rights and freedoms of natural persons, then you have to carry out a DPIA. So what do those rights and freedoms include? They are the right to data protection and privacy. So if there's a risk that the data is going to get stolen, or if there's a risk that in some way the data won't be protected and kept private, then that is a high risk to the rights and freedoms of natural persons. There's the freedom of speech, freedom of thought, freedom of movement, prohibition of discrimination, and the right to liberty, conscience and religion. So it's got to be quite serious stuff here. Then the Article 35(3) goes on to say when is it particularly required, and they give some examples as to when a DPIA might be required. And it's if processing is done on a large scale of special categories of data, and we know what those are now, don't we? I'm sure if I asked any of you, you would be able to tell me what that is. That's the sensitive data that we've talked about quite a lot. And just as a reminder, that is racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data for the purpose of uniquely identifying a natural person, data concerning health, data concerning sex life or sexual orientation, that's sensitive data. So if you are processing sensitive data on a large scale, then a DPIA is likely to be required. So if you're in the healthcare sector, for example, then a DPIA is likely to be required. The other one is in relation, probably nobody in this group will be doing it, but relating to criminal convictions and offences. So if you're doing large-scale processing of criminal convictions and offences, then you need to be carrying out a DPIA. If you're systematically monitoring publicly accessible area on a large scale, then That is also a case for a DPIA, so an example of that would be CCTV, if you're doing that on a large scale. And also where there is a systematic and extensive evaluation of personal aspects based on automated processing, including profiling. So this is so systematic and extensive automated profiling, automated processing, including profiling, and on which decisions are based that produce legal effects concerning the natural persons or similarly significantly affect the natural person. So the keywords there are systematic and extensive, automated processing, including profiling, and, this is the key bit, on which decisions are based that produce legal effects. So I think I answered a question in a group a while ago about, there was a question whether tagging in Infusionsoft or similar would be, it would be caught under the automated decision-making provisions of GDPR. And I did a video on that and explained that it's only if that automated processing, including profiling, produces legal effects or similarly significantly affect. It's got to be, and I read out some examples of what they were. It's got to be, it's got to be something serious. So a DPIA is only, it's not only required in those circumstances, it's particularly required in those circumstances. The overriding test is whether the processing is likely to result in a high risk to the rights and freedoms of individuals. The catch-all, this is in recital 91, the catch-all is other operations where the competent supervisory authority, which in this case is the ICO, considers that the processing is likely to result in a high risk to the rights and freedoms of data subjects, in particular because they prevent data subjects from exercising a right or using a service or a contract, or because they're carried out systematically on a large scale. So again, the keywords there are, it's systematically, it's large scale, it's the high risk to the rights and freedoms of the data subjects. So you've got to be doing something pretty extensive and pretty serious. There is a carve-out in recital 91, which says that the processing of personal data should not be considered to be on a large scale if the processing concerns personal data from patients or clients by an individual physician, can never say that word, no, still not said it. Anyway, healthcare professional type person, or lawyer. In such cases, a data protection impact assessment should not be mandatory. So if any of you fall within that category of being an individual physician, or other healthcare professional or a lawyer, and you're processing a lot of personal data in that capacity, you don't have to carry out a DPA. So there are 9 criteria to be considered when identifying processing as high risk. I think I'll just post those under this video to save me reading them out, so that if you do fall within this this category of business, then you can look at that. I'm going to give you some examples of projects that might require a DPIA. One of them is storing for archive purposes pseudonymized data that's been pseudonymized, personal sensitive data concerning vulnerable data for subjects of research projects or clinical trials. So this is, let me say that in English. So that is where you've got vulnerable data subjects, so vulnerable individuals, and you've got sensitive data. I've just told you what that means, and they're taking part in research projects or clinical trials, and that data has been put into storage for archive purposes, and it has been pseudonymized, I think is how you say it. Now, the possible relative criteria, and you'll see those are the 9 criteria that I post under this video, but the possible relevant criteria for that are sensitive data, data concerning vulnerable data subjects, and it prevents data subjects from exercising a right or using a service or a contract. So that would need a DPIA. Another example is where a company systematically monitors its employees' activities, including the monitoring of the employee's workstation and internet activity. And there the possible relevant criteria would be systematic monitoring and data concerning vulnerable subjects. Next one, gathering of public social media data for generating profiles. The possible relevant criteria for that would be evaluation or scoring, data processed on large scale, matching or combining of data sets and sensitive data or data of a highly personal nature, and that would require a DPIA. Examples of projects that aren't likely to require a DPIA: an online magazine using a mailing list to send a generic daily digest to subscribers. The possible relevant criteria is data processed on a large scale, but because that's only one criteria, it's not likely to be required. The DPIA is not likely to be required. And another one is an e-commerce website displaying adverts involving limited profiling based on items viewed or purchased on its own website. The possible relevant criteria would be evaluation or scoring, but again, because it's just one criteria there, it's not likely, a DPIA is not likely to be required. Okay, so I think that is probably all I want to say about that. The key thing really is just all I want you to take away from this video is just to have a red flag to think, okay, do I need to carry a DPIA out or not? And if you're dealing with large-scale processing of sensitive data, then be aware of this, because chances are then you probably will need to carry out a DPIA. If you are systematically monitoring publicly accessible areas on a large scale, so like in that example that I gave there, if you're a company that is systematically monitoring employees' activities, then chances are that will need a DPIA. If you are doing a lot of automated processing, including profiling, and decisions are being made from that automated processing that produce legal effects or similarly significant effects, then again, chances are you'll need a DPIA. And the key thing to bear in mind is that it's any processing that's likely to result in a high risk to the rights and freedoms of natural persons, then you need to carry out a DPIA, and if you don't, then fines will apply. So I imagine that this video is only going to apply to a small percentage of you, but I just want to red flag that to you in case there is anybody in that in those categories, if you like. So if you are in those categories, then post below this video if you think that one might apply, and then I can direct you to the relevant resources about how to actually carry out a DPIA if you need to do so. Okay, so that's all I'm going to say for now. For those of you who are wondering about the sign up for the checklist, I'm just about to work on that now. So if technology behaves itself, then I should have that posted in the group, hopefully before midnight, because I did say that it would be today. So I shall do that. For those of you who've received your GDPR pack or the first instalment of it, I don't know if you've had a chance to have a look through that yet, but hopefully you'll find that that is fairly comprehensive for you. And looking forward to get cracking on week 2 of that. If you haven't yet ordered your GDPR pack, then it's still at the introductory price of £97. The details are in the pinned post, so do go and check that out. But for now, I shall leave you with that, and I'll see you tomorrow.